Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about provocation and murder. Cases that should have gone to the Supreme Court of Canada, but didn't. Amendments were made to the criminal code many years ago in the Harper era that prohibited the argument of provocation from being used to reduce murder charges to manslaughter charges in many circumstances in which it had previously been used. The criminal code now constrains significantly the ability to mount a potential provocation defense. A number of individuals in Canada brought applications to constitutionally challenge these changes to the legislation, arguing that they were unfair and inconsistent with the Constitution. The Supreme Court of Canada was asked to hear applications after all of these individuals across these different cases lost their constitutional challenge applications to determine the constitutionality of the provision. And the Supreme Court of Canada declined to hear these cases. Interestingly, all of these cases arise in Ontario. They are all cases coming from one jurisdiction where one court of appeal has ruled a certain way. Not every appellate court in Canada has opined on the issue or has had the opportunity to determine the constitutionality of the provision. And in Canada, appellate courts from different provinces don't write judgments that are binding on other appeal courts. The fact that the Supreme Court of Canada chose not to hear a case about the constitutionality of something that is a potential defense, or not really a defense, but a reduction strategy for somebody facing one of the most serious charges in the criminal code with one of the most serious penalties you can get, is the type of thing that the Supreme Court of Canada should be taking on. It's not in the public interest to leave the door open for inconsistent judgments to be rendered in different provinces, because then there is criminal law that is meant to be federal applied inconsistently across the country. If the provision is unconstitutional in British Columbia, it may still be constitutional in Ontario. And so a person in British Columbia may be in a better position to make full answer in defense to a charge than a person in Ontario is. The Supreme Court of Canada should have recognized that important constitutional challenges to significant changes in the law for serious offenses are the type of thing that always meet the test of national importance and should be heard by the Supreme Court of Canada. The constitutionality of this provision probably would have been determined the same way for the reasons the Court of Appeal of Ontario gave by the Supreme Court of Canada, but that doesn't mean it wasn't important for them to ensure consistency in the law and to prevent potential conflicts in the law from arising in the future to take this case. Ultimately, the Supreme Court of Canada may end up having to revisit the decision to hear a question on the constitutionality of these provisions. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.